Hello, my name's Jasmin, and this video aims to teach the class when an employer owns the right to an invention. Imagine you're a creative employee who finds the time and has the inclination to invent a product or improve a process. Then ask yourself, do I own that invention, or is it the property of my employer? In a contemporary workplace where technology is advanced, it is imperative to understand the parameters of inventing whilst acting as an employee. The Australian Patents Act 1990 does not contain any express provisions for dealing with the ownership of inventions that are generated during the course of employment. In the absence of this statutory protection, the ownership of inventions is governed by the employment contract, either expressly or impliedly. Where there is an express term in the contract to the effect of assigning the rights of such inventions to the employer, the ownership will vest with them. As ruled in Electrolux and Hudson, so long as the express term is not wide enough or unreasonable enough to constitute a restraint of trade clause, it will effectively give the employer ownership rights. Employers can also be given an implied right to ownership over employee inventions in the absence of an express term. Justice Nettle in Victoria University of Technology and Wilson articulates that if the invention is the product of work which the employee was paid to perform, or in other terms, has a duty to invent, then the employer will have the ownership rights. However, the employer will only be entitled to ownership rights where the invention was created within the course and scope of employment. What then does it mean to act within the course of employment? Well, consideration is given to a range of factors that indicate whether or not the invention was a product of paid duties. The University of Western Australia and Grey identified that just because the employee has an obligation to research, or that inventions are incidental to research, does not mean that the employee has an implied duty to invent. Furthermore, the following factors are not singularly determinative in proving that the invention was within the realm of employment. Firstly, that the employee used the employer's equipment to improve a process or invent a product. Secondly, that the property was created during paid work hours. Or lastly, that the property was created at the employer's premises. In situations where the employer is found to have ownership rights, the employee will then hold any invention or patent on trust for the employer. Alternatively, where it is found that the contract has no express or implied term, the employer has no legal claim and no right to ownership over the intellectual property. Just remember, if you're an employer, it is in your best interest to include an express term assigning the rights of all intellectual property to the company. Without such contractual protection, there is a probable risk that the employee will alternatively be awarded the ownership. So long as the employee can check off that the invention was not created within the course of employment, they will effectively be assigned the rights to such invention.